All India Lawyers Union Kannur District Committee to this program. So, Madam, we are on behalf of All India Lawyers Union Kannur District Committee, we invite you to deliver a class on art of cross-examination.
Thank you.
Thank you.
I'm really grateful to all of you because it's a very great learning opportunity for me. I would like to congratulate the organizers behind this entire process because it's a yeoman service that you are doing. I'm here only to learn from this side. That's all I would like to tell you. Let me begin with this caveat. I'm 30-year-old in profession. I'm trying to learn something from each one of you. Today we have chosen the topic art of cross-examination. When we say art of cross-examination, let us start to understand what exactly is the meaning of art. Any creative activity is art. Art is a creative activity. It has got three components in it. One is technique, the other one is creative skill, and the third one is imagination. So art of cross-examination should also have all these three elements: technique, skill, and then little bit of imagination. Now, let us try to understand what is technique and what is skill. When we say technique, it is that component which tells us what and why aspects. What is it? Why is it so? For example, tomato is a fruit. What is tomato? Tomato is a fruit. What element has come there? Why tomato is a fruit? Any edible part of a plant with seeds in it is a fruit. Hence, tomato is a fruit. So now you know what and why components. This is technical aspects, techniques. Now, let us go to the skill aspect. Skill aspects has different variables within it. That means to say, keeping aside what and why components, when, where, how, who, whom, all these aspects fall under the category of skill. This, you have to inculcate this skill. And how do you exhibit your skill? It gets exhibited on the spot when you are cross-examining somebody else. As far as technique is concerned, you can prepare yourself outside the courtroom also. But as far as the skill is concerned, then and there you have to exercise. And it requires little bit of imagination also. That is why we say it is art of cross-examination, because it has got three elements in it. One is the technique, the other one is the creative skill, and the third one is the imagination. Now you see, let us understand another aspect. Cross-examination involves understanding of facts. What exactly is a fact? Fact does not have its own meaning. Facts exist by themselves, that's all. Facts just exist. But facts get a meaning through the frame with which you are looking at it. For example, I'll give you an example. I'm wearing spectacles now. It's a fact, all of you are seeing now. I'm wearing spectacles. Madam Susheela is wearing spectacles is a fact. Why is she wearing spectacles? She is wearing spectacles because she is 58-year-old. One answer. If you want to see through this frame, you can see this fact through that frame. Second, Susheela is wearing a frame because This is a Shabana Azmi model, and she is a great fan of Shabana Azmi. If you want to see it from that angle, you can see it from that angle because you are seeing it from that frame. Third, Susheela wants to give herself an intelligent look. So, in order to project herself to be a very intelligent person, she is wearing that spectacle. Otherwise, she has no problem with her eyesight. This is the third perspective. Now, you see, what is truth is different, but you can always look at a fact through different frames. Now, what exactly is out of cross-examination? You are making another person look at the facts through the frame in which you want that person to look into it. For example, you want a fact is there presented before the court. You want the judge to look at that fact in a given manner. So you are driving that judge through your cross-examination to see the fact in this angle through this frame. That is what cross-examination is all about. Now, another aspect that you need to understand is, what does a person depose in the court of law? He can depose anything regarding what he has seen, what he himself or she himself has heard, or what they have experienced, or what they have perceived sometimes. What they have seen, heard, felt, experienced, and perceived. These are some of the aspects about which the cross-examination will take forward. Now you see, when I say what he has seen, to that extent they will give this deposition. I remember a case, it was a case where a politician was involved in a murder case. So the eyewitness was there. The cross-examination was going on. You were there, yes, everything went on. What happened then? Wind blew so heavily that I closed my eyes and then I did not see what happened. So till there he saw something and he said, thereafter he did not see. That was the crucial point. Who stabbed the other person was the question there. So that is where these aspects are very important, because what one has seen, what one has not seen, what one has heard, what one has not heard, what one has personally experienced, what one has not personally experienced. These are the aspects which you have to decipher after going through the examination in chief or the deposition by way of examination in chief. Now you see, what are the objectives of cross-examination? Any cross-examination should have an objective. Without objective, we should never go for cross-examination at all. One of the main objectives of this cross-examination is to separate truth from falsehood, number one. The second one is, cross-examination is always considered as surest test of truth. When we say it is surest test of truth, you will use cross-examination as a tool, as a lawyer, to help the judge see what is behind the door. What is behind the door? You are helping the judge to see. That is where the objective is very important. And another aspect is, cross-examination is a wonderful tool to see whether the logical gaps can be straightened. I'll give you an example for this. About 20-25 years ago, in the beginning years of my practice, I had filed a petition for divorce under section 13B of the Hindu Marriage Act. Divorce by mutual consent. In those days, the question of filing affidavit of examination chief was not there. They had to literally get into the witness box and speak. It was a divorce by mutual consent, very simple case. The lady was suffering from 4th stage of cancer. Husband had agreed to give her 5 lakh rupees alimony. There was a pressing need for that lady to close the case. Even her brothers were interested, because if she dies, the husband need not have to give anything also. So they were worried that the case should get closed at the earliest. Unfortunately, there was a boycott. There was a resolution in our bar association that nobody should go to the court hall. We all abstained from the work. When the case was called, this lady went inside. The husband also went inside. And she said, I have the matter is very urgent. It has to be taken. Judge said, look, today your lawyers are not there, but if you are prepared, I can take it. Fair enough. The lady said, I will go ahead. What's your name? Yes. What's your qualification? MA in sociology. What's his qualification? He had got double masters, husband. We got married on such and such a date. We are not willing to stay together as couples. So the divorce decree may be granted. Okay. Have you given free consent? The judge asked. Judge was asking one question after the other because we were not there. Have you given free consent? The lady said no. Madam, have you given free consent? Again, repeatedly the judge asked. The lady said, no, I have not given free consent at all. Who is your lawyer? So and so. Did you tell her that you have not given free consent? Yes, I told my lawyer also. I am not going to give free consent. Immediately the judge said, stop cross-examination. He wrote, so and so says she has not given free consent. So this petition cannot be taken. Anyhow, for orders tomorrow. The bench clerk who was sitting there came running and he told me, madam, this is what happened. Look, I was really very engaged. Maybe I was 25, 26 or so. I was really afraid. What is this? Because the judge has also written that she says that about the lawyer. She told the lawyer that she has not given free consent despite that this case is filed. All those things is written there. I was really afraid. Then there was a senior advocate. I consulted him. He said, don't worry, we will resolve this issue. Next day, I give no objection to both of them. To both of them, I had filed a wakalat. For husband, and another advocate is engaged. For wife, another advocate is engaged. Now, the senior advocate seeks permission of the court to cross-examine this lady. There was a lot of discussion and then the court permitted. Only one single question the senior advocate asked this lady. Madam, what do you mean by free consent? The lady said, free consent means agreeing for divorce without any alimony. Look at this. That's all. The court also understood where the court went wrong. So immediately, the gentleman judge he was, so immediately everything got resolved. But one effective cross-examination, this is what is known as the objective of the cross-examination is to straighten the logical gap, if any, in the depositions. So that is where we have to think. Now you see, the idea is to see to it that the exaggerated versions are brought into its true dimensions. Sometimes witnesses give exaggerated versions. All of us speak in an exaggerated manner many a times. Unknowingly we start speaking. So it is common with the witnesses also. That is where one of the objectives of this cross-examination is to bring the exaggerated version into its true dimensions. For example, a witness may say, in a maintenance case, my husband has got lots of properties. Yes, lots of properties. Okay. Can you go on pointing which are those properties? Number 1, number 2, number 3. Finished. My husband always insulted me. Come on, tell me when all he insulted. Number 1, number 2, number 3. Exaggerated versions come to actual versions. That is where another objective of this cross-examination is to use this as a tool to see to it that the actual versions are placed before the court of law. Now you see, the true dimensions is what we say. You have to bring the true dimensions. To place the true dimension before the court also, we use this cross-examination as a tool. What are the talents required in order to inculcate this art of cross-examination. What are the talents required? First one is masterful knowledge of facts and legal positions. You should have not an ordinary knowledge, masterful knowledge of facts and the subject matter, and also that of the legal position, without which you should not step into the arena of cross-examination at all. First tip that I would like to request the youngsters to note down: don't start cross-examination without masterful knowledge of facts, legal positions, and the subject matter in issue. When I say facts, facts include not just the subject matter in issue in the case. It includes facts about the witness, facts about his relationship with the party, and facts about which the witness is going to depose. All these things you should have in your diary. Then only you should go for cross-examining the party. First tip is this masterful knowledge. The second tip is extreme caution. This is the second talent. You should always have this talent with you. Be cautious, extremely cautious. Know what not to ask, what we should not ask. You should always know that. Think 100 times before asking a question. Second talent, be extremely cautious. The third one is having self-control. Many times the party may irritate us, the opponent lawyer may irritate us. This may be used as a strategy so that we lose the track, or the court. With court also we may get irritated for various reasons, or we may have got irritated because of so many other things. But never lose your control. Have absolute self-control. I am only a lawyer here. I am here to conduct cross-examination. I have no other role to play. Have a self-control and then begin. This is the third one. Fourth one, you should have a specific talent, which is an instinct to discover the weakness of the witness on the spot. Within 2-3 minutes of the cross-examination, you should be able to catch up with the weakness of the witness. Some are very much, some have a great flair for appreciation. If you start appreciating, they will fall. Some, if you use your voice a little bit louder, they are under your control. If you speak very slowly, then also some will fall under your control. So you have to understand this chemistry of the witness. So identify and develop that instinct to discover the weak point in the witness who is under cross-examination. This is the second thing that we need to understand. Now you see, there are two components of cross-examination. One is the manner of cross-examination, and another is the matter of cross-examination. You must be thorough with both these aspects: manner of cross-examination, matter of cross-examination. In fact, as an youngster, I used to read this Francis Wellman's Art of Cross-Examination. Those of you who are interested in reading, please read that. It's a wonderful book. I always suggest people that they should read. Even those who are not in the legal field also must read this book. Francis Wellman's Art of Cross-Examination. He also refers to these two things: the manner of cross-examination and matter of cross-examination. A lawyer has to sincerely work on both these components before proceeding with the cross-examination. What is the foundation for these two components? Manner of cross-examination and matter of cross-examination. The foundation is same. It is preparation. There is no shortcut for preparation. Failing to prepare is preparing to fail. If you do not prepare well, you are surely going to fail. Cross-examination is considered as one of the most difficult but accomplished tool of an advocate. So do not fail to prepare. Manner of cross-examination also, with regard to manner of cross-examination also, you should have thorough preparation. Now when I say manner of cross-examination, there are some basic elements. The way in which we dress, the way in which we stand, the way in which we use our voice, how we move, how we sit. All these things fall under the category of manner of preparation. Always dress well. So, I mean, the professional, as far as the professionalism is concerned, I say that you should always be well dressed. I don't say that you should wear costly dresses, but you should be very neatly dressed. I'll give you an example. How this has got an impact, and how some people use this itself as a tool. I had filed a suit for injunction, permanent injunction. The landowner, the owner of the property, was my lecturer. She had problem because she had delivered a child and it was a cesarean, so she couldn't come. She gave power of attorney to the head of the department, my another professor. Brilliant man. Brilliant is not the word. The power of, in those days, the power of, with regard to power of attorney holder deposing before the court and all, so many citations and judgments of the Supreme Court, etc., were all not there. So he came there. He was very intelligent. The previous day we said, whatever you have said in the plaint, you please look into it, all those things. Finished, he came there. He came at 11 o'clock. Around 3 o'clock, the case was called. Hopeless. And in the evening when he comes to office, I said, sir, what happened to you? He said, madam, I came there at 11 o'clock. I was watching the other advocates. They were all moving here and there, going here and there. And when the case was calling, they were getting up in a hurry and then pulling out papers, taking this, and then in between they were calling the witness, some other their clients, and asking so many questions, all those things. But this man, our opponent's advocate, he came at 11. He sat there. And when the case was called, he didn't run. He came slowly from there. His shoes were polished. Look at the straight bands that he had. And there was not even a single stain in his glass. And when he came there and he leaned and he said, are you ready, Mr. A, to answer my questions? This question disturbed me a lot. Look at this. Are you ready, Mr. The voice that he has used here. The next question he put. Do you know, Mr. A? Please answer me. After thinking, don't be in a hurry to answer my questions. Do you know, Mr. A, that you are only a power of attorney holder of Srimati Dash? You are only a power of attorney holder. Madam, when he said you are only a power of attorney holder, I lost my strength. What do you say about these things? See, that's where Mr. Russell is known as the powerful cross-examiner from England. Somebody has said about the way in which he was cross-examining. How does Russell cross-examine? He produced the same effect that which a cobra produced on the rabbit. Look at this. How the cobra produces the effect on the rabbit, the same effect Russell produced. Here was a case where the other side advocate came in a dignified manner. He just leaned, moved forward and said, your body language also matters. So never ignore these things when you are going to cross-examine another person. Now you see, when this is called as a reflective question, what do you say is, see here, when he said, please understand, there are different types of questions. I will take you through different types of questions that we generally use in cross-examination. One of the types of questions is a reflective question. Please think over and answer. This is the writer he has given, the lawyer. The answer has to come from the witness after listening. So you are only a power of attorney holder. So that made a tremendous difference, and we lost the case, in fact. Now you see, why am I telling all these things? Many of our immediate friends who are also here will be knowing very well that in any communication, the effect of words is only 7%. But 38%, the effect of 38% of communication is through the tone, the pitch, the rhythm, the pass, pace, everything that you adapt. And the rest of the 55% is through your body language. So the 7, 38 and 55 is there. So what I request you to consider here is, when you are cross-examining, the manner of preparation also includes which word you have to press, which word you have to take it very lightly, which word you should use a very high volume, which word you should ask in a murmuring voice or pispisa voice. Go near the witness and then you ask him some question. That question will give you a different answer, that which you wanted the witness to answer to him than the answer which otherwise the witness would have given to you. This is another technique that you need to understand. Now you see, let us go to some types of questions, general types of questions. There are, I suggest that at least 40 different types of questioning skills one must inculcate. But for the present, I have chosen around 10 to 12 types of questions, which I will introduce you now. And then when we go to case histories, I will tell you which type of question we have used there. So first one is, all of you must be knowing, very familiar, you must be very familiar with, it's an open-ended question. What's an open-ended question? An open-ended question is a question, the answer to which runs in several sentences. If you ask an open-ended question, the party will go into explanatory mode. Supposing you ask me, tell me about your married life. I'll start telling you for 10 hours, 15 hours, 20 hours, I can tell you. This is an open-ended question. Parties get into explanatory mode. I always suggest, excepting in rarest of rare circumstances, a lawyer should not use open-ended questions in cross-examination. We are not supposed to ask open-ended questions. Do not take the witness to an explanatory mode at all. You might have seen the prosecutors in criminal cases. They will say, on 6/5/2015 at 4 o'clock, tell me what happened. So he will explain the whole thing. The witness will explain. They will use it, but we are not supposed to use it in the cross-examination. Do not use open-ended question unless you are very sure what you are going to achieve, number one. The second one is closed-ended questions. Closed-ended questions are questions which are specific, which will have very short answer. 1 word, 2 word, 1 sentence, maximum 2 sentences, that's all. So 1 sentence itself. So closed-ended questions, it is better to use closed-ended questions. Frame only closed-ended questions when you are putting questions to the witness, number 2. The third type of question, dichotomous questions. You should work too much on this type of question. Dichotomous questions are questions, the answer to which are either yes or no. Were you there on that day? Yes. Was your father there? No. Was your dog there? Yes. Yes, no, yes, 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 no, no, no. I don't know. These are yes or no dichotomous questions. So it is better to prepare the questions in such a way that the answers come in the form of yes, no, or maximum I don't know. Next, inch questions. Inch questions are questions to which the answer is given in one word. Are you married? Yes. When did you get married? 1988. How many children do you have? 5. So inch questions. You should know when to use this inch question. Next is foot question. This is very important. In foot question, what you do is you draw the attention of the witness to a particular document, a piece of paper, or a particular information, and then put questions to him. For example, you can show a photo to him. Look, this is the photo in which you and your wife and child are there. Look, this is the photo of that scene where the incident had happened according to you. This is one document. See, this according to you is the will which you have drafted. So this is a foot question. Now, why do you want this? You want this because I told you manner of cross-examination and matter of cross-examination. In order to do your perfect homework on the matter of cross-examination, you should know which are the foot questions that you are going to ask about the document. If you are on the civil side, practicing on the civil side, about the document. Even on the criminal side also, sometimes we need to look into the reports, etc. So you should know which are the foot questions that you are going to. You have to have a separate paper for that. FQ, you have to write foot questions and you have to ask, because you should not forget there to ask those questions. Next, rating scale questions. Supposing it is a matrimonial case. How do you rate your marriage? Good, bad, or okay? She may say worst. She may say okay. If it is okay, supposing you are for the husband who has filed a petition for restitution of conjugal rights, you can tell the court, look, though she has filed a petition for divorce and my client has filed a petition for restitution of conjugal rights, when she says, how do you rate your marriage? When she says it's okay, it's not a case for divorce. You can use the rating scale question. Criminal cases also we use this. How far were you from the place of occurrence according to you? 5 feet, 10 feet, 20 feet away? We are. So you are, so if scale itself is 5 feet, isn't it? So when you say how far you were you at a distance of 5 feet, 10 feet, 15 feet means if he is extraordinarily brilliant, he will say within 5 feet. Otherwise, he will say beyond 5 feet. 5 feet, madam, he will tell. So rating scales questions should be very cleverly framed as far as these criminal cases are concerned, where you want to bring precision and you want to show that this could have happened or this could not have happened, and you can't look at the fact from this frame. You have to look at this from this angle. That's where you use that. Now you see another type of question, circular questions. Circular questions are questions the answer to which is given by a party not only considering his interest, but the interest of the persons that are going to be affected by his answer. I'll give you an example, then you will understand this. Let us not go into the technical definition of that. For example, according to you, your husband gets 30,000 rupees salary. In a section 125 proceedings, you will ask this question. 125 proceedings, The salary slip is there, 30,000 rupees. Your husband, madam, you are cross-examining the wife. Madam, your husband has to take care of his father, mother, his sister, you and your child and himself, 6 members. Now, you and your wife, your child are living separately now, according to you. What do you think he can contribute? So she can't tell out of 30,000 he has to give 25,000 rupees now, because she has to think of the interest of all these people, isn't it? That's how you frame a circular question. In matrimonial cases also, sometimes we use this a lot. For example, a husband says, I can't, she is insisting upon a separate house, I can't provide a separate house. This will be his case. She doesn't like my mother. So what is it that you can do? Supposing I am wife's lawyer, I will ask, what is it that you can do, mister, so that you are happy, your wife is happy, and your mother is also happy? I put the same question to wife. If I am husband's lawyer, what is it that you can do so that you are happy, your mother-in-law is happy, and your husband is happy? What is it that your mother-in-law can do according to you, so that you are happy, your husband is happy, and you are not? Generally, the circular questions are asked. Supposing nowadays, what happens is, in high-level arbitrations and mediation, sometimes where they have to look into several documents, we frame these circular questions and give it to the other side well in advance. Let them go through this and then say, look, this is the asset, this is the liability, this is the chartered accountant's report, this is that RBI's guideline is like this, all the mergers and acquisition cases. We give these questions. So when they are answering each of these questions, a partner cannot think about himself alone. He should think of the interest of the other partners also, and he will come out with an answer. That's how this area is gaining a great lot of momentum. Now you see, after the circular question, let us go to bipolar questions. In case histories that I'm going to deal with you at the later part of this session, I'll take you through some strange bipolar questions. Bipolar questions are questions to which the answer can be extreme. You should think, be prepared. It can fall on this side or it can fall on this side. If you are prepared, only ask bipolar questions. Otherwise, don't enter into the field of asking bipolar questions at all. Next, convergent questions. The convergent questions are questions to which an answer is given based on informations, facts that are all in the hands of the witness, and the answer comes at a deeper level of thinking. For example, you put a question to a witness. How did your sister-in-law die? Husband says, he will think, and then he will say, she committed suicide. This may be an important information for you. So you are asking convergent question where the person who is going to answer will give the answer with a deeper level of thinking. Why did your first daughter-in-law go away from the house? You will ask the mother-in-law. She has to think and then give answer. Next is divergent questions. See, divergent questions will give multiple options. Divergent questions are generally asked to some experts sometimes. For example, medical expert. In a criminal case, he says, because of this weapon, this wound has happened. Okay. You will ask the expert, sir, forget about the weapon. Look at this wound. The size of the wound, everything will be there in the certificate. You will show foot question. You will show the certificate, show the document to the doctor. He will see, look, this is the description of the wound. In what all circumstances this wound can happen? He will give multiple options. It can happen because of this, it can happen because of this, it can happen because of, instead of you suggesting when he moves under the window pan, it will happen. Nowadays, there are no such windows at all, which will open like this and close like this. They're all sliding doors nowadays. Now, I'm just generally telling you. The question here is, divergent questions are asked where you want to create multiple options. Some questions are also known as echo-parroting questions. Echo-parroting questions are the statements made by them. You are going to repeat the same in the form of a question. For example, my husband $50,000 per month. You are asking. You are no, madam, around 30,000. She will come down. You saw the incident at by standing at a distance of 2 feet. So close. When one was hitting the other, according to you. Not 2 feet, madam. 3 feet, 4 feet. Then you will go to rating scale question. About 10 feet, 15 feet, 20 feet. 20 feet, madam, not 2 feet. See, this echo parroting has got what they have said. You are repeating the same thing, nothing you are doing. So you are using this echo parroting. Next, hypothetical questions. You are putting the witness into a hypothetical situation and then asking a question. Supposing this had happened, wouldn't this have happened according to you? Yes, there are possibilities. You ask these hypothetical questions even with the medical experts also. Sometimes with investigating officers also, IOs also, we ask these questions. Supposing this had been done like this, this wouldn't have happened. Supposing this fingerprint experts, we do this. So had you applied this method, probably the result would have been different. Had you done this test like this, the result would have been different. So we are putting him into a hypothetical situation and making the witness stand in the hypothetical situation than in the situation in which he stood. And we will bring, look, if this had happened, this wouldn't have happened. For example, in a criminal case, an eyewitness, one of the witness says, on that day, complainant says, complainant is not an eyewitness. Complainant says, on that day, so-and-so was there. He was the one who called me. But that person who gave first information to the complainant is not even noted there as a witness. He should have been an eyewitness. That person who was there on the spot, he is not even an eyewitness. So that is, you will put him into that hypothesis. On that day, according to so-and-so, so-and-so was there. Is he here? So you are taking them to a hypothetical situation and then you are making them answer the question. These are some preliminary questions. There are several, deeper level of understanding of all these things. When we take each case law and go deeper into each of these things, there is, lot that we can work on these questions. Nowadays, why I request all of you to take cross-examination very seriously is, sometimes if you are very serious about this profession, then people will come to you. Some youngsters are coming and giving their papers to us and they are asking us, madam, give us 4 or 5 questions that we can ask. Only 4 or 5 questions they will ask you to frame, that's all. And with 4 or 5 questions, definitely the answer is going to be this way or that way. Sure. For that, they are going to pay you very heavily. So please, you can take this as a profession also. Very seriously you can consider this. Now this is with regard to manner of cross-examination. When we said manner of cross-examination, understanding and using different types of questioning skills also falls under that category. Now let us go to matter of cross-examination. When we say matter of cross-examination, again, there has to be preparation, because I told you manner of cross-examination and matter of cross-examination both fall under the same foundation, that is the preparation. Now we say preparation means you should have read plaint 100 times, written statement, issues, depositions, earlier depositions, or the examination in chief, and all the documents, and you should have read documents word by word. This is the preparation. Particularly civil cases, even in criminal cases also. You have to read from the complaint, FIR, charge sheet statements, PF report, everything you should read. Don't leave anything. You will get something somewhere. When you see, after this preparation, you have to sit with your client and try to know everything about the witness from the client. Look, your opponent has cited so and so as a witness. Tell me something about that witness. Take all information about the witness from your client and also find out from your client what are the questions that he wants you to ask to the other side. Later you can take a call whether to ask that question or not. But because they are the master of their cases, we cannot take mastery over their case. It is their case. So ask them, because why I'm telling you is cross-examination should be done without any tension. You can't promise your client that you are going to win every case. Client should know that these are his limitations. So it is better we prepare the client, we ask the client, and we should ask the client, what are the questions that you expect me to put to the other side or to the witness, so that the answers will benefit you. Number 2. 3. You also ask your client as to what he expects you to do, so that you can overcome what the witness has said in examination in chief. How do you overcome this? In examination chief, he has said this. How do you overcome this? What do you want me to do? You tell me. You ask all these things. And I suggest that the document has to be read from top to bottom. In fact, I was a panel advocate for several banks. Before I was a panel advocate, for many of the borrowers, I was an advocate. You must be knowing, one is an acknowledgement of debt is something. In those who are practicing on the banking side, they will be knowing. Another is a loan revival letter. The day on which they give the loan, on that day itself, usually they take all these things. In one case, our contention was that the loan is time barred and they could not have taken that. The loan revival letter was there. I just put a foot question to the manager. I showed him the document. Look, this is the loan revival letter. Yes. Just before 3 years, the borrower had signed that. That means there is a revival. From that day, the limitation will continue for another 3 years. I said, yes. Then you see the date. The loan revival letters are printed. When was it printed? The loan revival letter somewhere you will get, but you should meticulously look for it. This is an area of preparation. See, the elements that we need to understand as far as this cross-examination is concerned is, by and large, confine yourself to what is said in the examination in chief. Many a times, what is pleaded might not have been told in the evidence, brought in the evidence at all. If it is not brought in the evidence, you don't try to bring it into the evidence. So confine yourself to what is said in the examination in chief. First, you have to take the examination in chief and find out whether there is something which is testified against your client or not. What are the elements that are testified against your client? Mark down those things. Has the testimony of the witness injured your client or not? Again, verify. He might have said something, but how far it has injured your client, that also you have to see. And go one step further and see. Read the examination in chief. By reading this examination in chief, will the court tilt in favor of the opponent? Is there a possibility? These are all the preparations for you to decide whether you should cross-examine a witness or not. That is very important. Is there a necessity to cross-examine? If there is no need to cross-examine, don't cross-examine. But there are some situations you should go further step. Even if there is nothing that I can cross-examine, is there some information that I can get through this witness which will be helpful for my client? That aspect also you can say. I will tell you when I take you through a case history, I will tell you how this has helped me. Examination in chief, whatever he has said, it's okay. It is there. But something else can you derive through this client so that will be helpful to your client. That is another aspect that you need to see. I suggest there should never be browbeating or shouting or confusing. Your opponent's witness or your opponent is not your opponent. Be very courteous, very calm and composed. You can take control provided you are composed and you do not lose your self-control, because that is one of the talents which I referred to you earlier. Now you see, though I do not suggest that all the questions be written on the paper and you hold a paper like this and start reading one after the other, I suggest that the questions must be prepared well in advance. Some questions have to be prepared. Unskillful questions cause more damage. So we should avoid asking unskillful questions and we should frame the questions in mind well beforehand before putting the question to the witness. Next, don't ask a question, the answer to which you do not know. If you ask a question, you know he has to give this answer. With that expectation, you ask that question. If you do not know the answer, don't ask that question at all. Number one. Number two, you can ask that question provided you are least bothered as to what answer the witness is going to give. Under those circumstances only, you can ask a question without bothering as to whether he would answer this way or that way. This is another thing. Now, why I suggest that you don't ask a question, the answer to which you do not know, means there is something known as the fish pulling the fisherman into the water. Fisherman has to hook and take the fish out. Sometimes the fisherman himself falls into the water because the fish pulls him in. Do not ask such questions is what I really suggest. Another important aspect that we need to understand while asking a question is, there are two different types of cross-examination. One is sequence questions they ask. One fact at a time. In one question, you ask only about one fact. This is a fundamental rule. One question, one fact. Multiple facts should not be there in one question. But about one fact itself, you can go on in a sequence, bring it to a logical end, and then go to another fact and series of questions. Some people have very different capabilities. They will, extraordinarily brilliant cross-examiners, they will ask one question with regard to one fact, they will ask some other question with regard to some other fact, and the first fact with regard to first fact, they will come after 10 sentences. They will get information from here and here, because sequential questions, what happens is the witness may get alerted. In order to avoid the witness getting alerted, you can also use this type. This is what is called as zigzag movements. You ask one question with regard to one fact, go to another fact, ask some other question, go to several questions, and then go to the first question again. This is how you can do it. Now you see, don't allow the person to see anywhere else. Look straight into the eyes, and you repeatedly tell him, look at me and answer. Please look into my eyes and answer. Mr. Witness, please look at me and answer. So this will, because when a person looks at another person, generally they cannot tell lie. That is where you should always draw his attention towards you. You should be so powerful as to capture his attention towards you. Your movements must be very, very dignified movements. You can't be standing in one place, leaning on the witness box like this. Beware of your body language. When you're asking one question, standing at a distance, and to the next question, when you're leaning towards him and asking some question and going back like this, that will give him a sensation in the mind of the witness. These things collectively will affect the way in which he is going to give answers to your question. This will definitely help you. Now you see, Irving Younger is a very famous professor. Those of you who are interested in watching YouTube and all, you can see Art of Cross-Examination by Irving Younger. And he has given 10 commandments. Generally, all of us follow more or less same commandments only. But for your understanding, I'll just take you through some of the commandments, and then let us go to the actual case histories where we have applied all this knowledge. One is that he says, be brief and succinct. Talent is not to use 2 words where you can use 1 word. Don't make your sentence very long. Ask very short questions. It's better you ask a question which does not run into 2 or 3 sentences or 5 sentences like that. Now, you have to ask questions in such a way that they are virtually leading questions. He should say yes, yes, yes. It is like the lawyer is singing, the lawyer who is cross-examining is singing, and the witness is telling only yes, 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 yes. That's all. The main song is by the lawyer. Yes, no, yes, no. These are all the things. That is how you have to take it. Now, escalating is another technique. You don't start the cross-examination with the exact question. You start with incautious questions. You ask something irrelevant also sometimes, and then bring them to that exact question. You start with some other question and then take to that question. This is called as technique of escalating. This technique you should try to build up. Next, when you are getting a favorable answer, allow him to get into explanatory mode. You don't ask any question. If you ask question, he will get alerted. But if he is giving favorable answers, be patient, listen to it, listen to it, listen to him. Next, you frame questions in such a way that he does not repeat what he has said in examination in chief. Idea of cross-examination is to see to it that he gives a different question here when you are cross-examining. That means you are also examination chief. So if you look at sometimes I look at the examination chief and cross-examination portions in several RSAs. So I in my own cases I have seen I now, when I look back at all those things, I see how foolishly I had asked this question. This question was there already in the examination in chief. There is no point in asking this very same question in the cross examination also. Witness to explain anything which is going to be damaging to your client's stand or position. Sometimes we have seen the judges writing witness volunteers. Before the witness volunteers, you put another question. Why do you allow him to volunteer? You ask a question, he will give the answer, then he will volunteer. The judge will take witness volunteers and he will take that also. Do not allow. Immediately you go to next question. Now we see, don't ask one question too many times. One question you ask, maybe he doesn't give a favorable answer. Don't ask the question same many a times. Just because you ask many a times, if he repeatedly tells his own answer, the very same answer, that will be very damaging to your client's stand. Next, don't go into summation. I'll tell you this. Summation should not be got through the client or the witness. You have to keep it aside. You have to hold the summation, reserve the summation for your arguments. One of the wonderful techniques that we have to develop is know when to sit back. When you should stop cross-examining, you should know. This Irving Enger gives one beautiful example. I'll tell you, this is a very wonderful story. A criminal case where the allegation was that the accused had bitten the nose of the complainant. This nose portion, this tip of the nose, it doesn't have any support of the bone. So if somebody, don't try, if somebody bites it very hard, then probably this portion will come out. This is the offense. Now an eyewitness is there. Eyewitness is examined. What are the questions put to him? Why did you are the eyewitness? Yes. Why did you go there? I went there for bird watching. Oh, you are interested in bird watching? Yes. Yes, yes. All the questions, yes, 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 he is telling. Where were you watching the bird? On the tree. Where was the tree? This side. How big was the tree? Huge tree. Where was the incident? Where did the incident happen? Behind me. I was standing like this, looking at the bird. Behind me, the incident happened. The lawyer could have stopped there. He went ahead. See, you should know where to stop. He went ahead. He said, if you are looking at this side watching the bird, how do you say that you saw the incident? Is it possible? Then he said, no, when there was a screaming, I turned that side. At least now he could have stopped. The lawyer went one more step ahead. You were watching the bird, turning this side. Then you heard somebody screaming, so you turned this side. Okay. But how do you say that he has bitten the nose of this person? I could say that because I saw him spitting the nose and holding it in his hand from his mouth. This summation was horrible. Why should he have done this? The lawyer should have stopped at the first instance. That's where we say, don't go into summation. Leave this. You could have used this. Look, he was watching the bird. This was on this side. So there was no possibility for him to see who has bitten the nose. Maybe the nose is bitten, but by whom? We cannot come to a conclusion that this accused is responsible for biting his nose. This could have been a better version. That's where we say, know when to sit down is one of the principles that we have to follow. Now you see, let us go to some actual case histories. Now it is 4:11, I think, 4 o'clock, 12 minutes. My plan is to go till 5 o'clock with some case histories. Before 5, if I complete, probably you will all be happy. Otherwise, maybe you're all feeling
No,
bored.
ma'am, we can continue up to 5 o'clock. Then we can have the questions.
Okay, fine,
Okay.
fine. Wonderful. See here, one technique that we use is known as steering or navigation. What do you mean by steering or navigation? You should know from where you are starting your journey and where you are going to, where you want to reach. That is navigation. Identify the destination where you want to reach. I'll tell you a small case history so that we will learn these techniques, that all that we have learned till now, we will adapt it practically into practical scenarios. Two sisters had filed a suit for partition against the younger sister. So totally there were 3 sisters. Suit for partition. Property belonged to Mother Chaudamma. When a Hindu lady dies, all the 3 will get equal share, 1/3 share. Suit was filed for partition. The defendant was youngest sister. Her contention is, plaintiffs are not my sisters, number 1. Number 2, Chaudamma has, I am the only daughter of Chaudamma and Chaudamma has executed a will in my favor. This is the simple case of defendant. Now, issues are whether plaintiffs prove that plaintiffs and defendant are sisters. They are whether the plaintiffs prove that plaintiffs and defendant are daughters of Chaudamma, number 1. Whether defendant proves that there is a will in her favor. These are the 2 issues which are important. I'm going to leave out all other issues. Now you see, how do you cross-examine here? Unfortunately, plaintiffs had got married when they were less than 10-year-old. So there was no document, voter list or anything to show they are daughters of so-and-so. They had not even gone to school. Whereas the younger sister defendant had stayed with her parents for a long time. She got married at the age of 21. So she had everything to prove that she is daughter of Chaudamma and Chaudappa, who were their parents. We did not have anything to show that plaintiffs are daughter of Chaudamma. Added to this, there is a will. I thought, if there is only daughter, the question of executing a will itself will not come. Who will execute a will in favor of only daughter? Because by default, it will go to daughter only. But nevertheless, if tomorrow it is shown to the court that plaintiffs are also children of Chaudamma, then the court may think, in the absence of anything being done with the will, the plaintiff's case for partition cannot be considered. So it was a very ticklish position. How do I go about this? The defendant's evidence. Defendant was summoned. She was there. We asked a question. When is the last you met the sisters, the plaintiffs? I have never met them at all. Okay. That plaintiff who is wearing blue saree, she looks exactly like you, excepting that you are fair and she is dark. Isn't it so? She doesn't answer. I repeat the question. She doesn't answer. Then I ask this. Did you hear my question? Yes. Did you understand my question? Yes. Tell me why are you not answering this question? I raise my voice a little bit and ask them. Tell me why you are not answering this question. Still she keeps mum. Then I request the court. Kindly note down my questions and also note down the demeanor of the witness, because you should know to request the court to note the demeanor of the witness. This is very important because tomorrow we can take an adverse inference. She was not prepared to look into the eyes of her sister and plaintiffs because she was somewhere guilty that she and one of the sisters looked almost like twin sisters. This is one aspect. Let us forget about it. Next comes the question of the scribe of the will. He came there. His examination chief affidavit was there. I put this question to him. You are a very famous scribe, very sought after scribe? Yes. He's very happy when I said this. People wait to get things done from you? Yes, he said. You want to see this will? You want to read this will? Exhibit D1? No, no. I can remember everything. Look at his confidence level. So I could make out that here is a person who is overconfident. Tell me, Mr. Scribe, with your experience, how many wills you would have drafted? More than 100? Why people draft? Why people write will? In order to see to it that their children do not fight over the property after their death. I told you first, sometimes there may not be anything in the document or anything in the chief examination which needs to be cross-examined, but find out if you can elicit some information which is in favor of your client through the witness. This is what one of the points that I gave you earlier. Now look at the point from where I am going, where I am now navigating. So according to you, people write will in order to avoid dispute with regard to property amongst their children. In this case also, okay. Was there any difference between 3 daughters of Chaudamma? Yes. So through this witness, what I am getting, that Chaudamma had 3 daughters. This information I could elicit. You have written such a beautiful will, which is nearly 5 to 6 pages. Okay. You have got tremendous patience, Mr. Scribe. Who gave you all the, lots of inputs? How did you collect these inputs? Amazing. How long you should have been seated with somebody. Oh, Sannamma's husband gave me all the information. I sat with him for days and days and then I drafted it. Who is Sannamma's husband? The youngest daughter's husband. So it is, so did you not leave out anything that Sannamma's husband said to you? No. I have written everything verbatim, whatever Sannamma's husband has said. That's all. I close my cross-examination. What did you get here? I got both the points. One is Chaudamma has got 3 daughters. Then I got another thing, that is the will was not drafted as per the instructions of Chaudamma, but as per the instructions of the beneficiary's husband. This is another thing. Now we see in the will, it was written, Chaudamma, to my only daughter I have written this will. I could have confronted this to him, but bipolar questions. If I ask him bipolar question, extreme answers, he may give any answer to that, he may get into explanatory mode. So I did not want to take that risk. But I can always use that as a material against Sonnamma, because tomorrow I can show. Look, here the scribe has written, and now my only daughter, I am executing this will only in favor of my only daughter. But in the cross-examination, he is telling that Chaudamma has got 3 daughters and there were differences amongst them. So in order to avoid that, the will was thought to be written. Whatever it is. Now you see, there is difference between discrediting the witness and discrediting the testimony of the witness. This distinction we should know. And I told you, as far as preparation with regard to matter of cross-examination, I told you should have complete hold over the legal positions also. You should know the difference between execution of a document and signing of a document. Maybe there is signature of Chaudamma or LTM of Chaudamma, but just because there is LTM of Chaudamma, can court come to a conclusion that the document is executed by her? There is difference between executing and affixing thumb mark or affixing signature. So that, with regard to that, you should have lots of knowledge. If you have done that homework, you will not ask any question, further questions. You will stop at that. About 6 questions, and the suit was decreed in favor of Kempamma, 1/3 degree, 1/3 each they got. This is how you navigate. Now you see, I will take you through another case history. See, you should know how to keep track. You should read the examination in chief or the evidence given by others or the questions that you have asked. You should not forget the question that you have asked earlier and go to the next question. I'll tell you an interesting case, 376 IPC, rape, offense of rape. The advocate cross-examines the victim and complainant. To the victim, he puts these questions. Look, I put it to you, I suggest that you never had any acquaintance with the accused at all. I deny, she says. He again says, look, your uncle is a panchayat member. This accused wanted to contest in the forthcoming elections. He would have won. In order to tarnish his image, your uncle has instigated you to file this false case, though you do not have any acquaintance with this person. I deny. Finished. Okay. Again, this person is asking, I put it to you that you have been riding bicycle ever since you were 10-year-old. I deny. I suggest, I put it to you that because you have been riding bicycle from 10 year till now, that is 24-year-old, the doctor has wrongly concluded that you have been exposed, but no offense has been committed. Look at this. First he says no acquaintance. If you had no acquaintance, how do you know that she has been riding bicycle from 8-year-old to 24-year-old? This is something. Okay, this is also something. Just leave it aside. Third one. When she denied this also, he goes one step ahead. He says, look, I put it to you that you wanted to marry this accused who is a very handsome and rich person. It was a one-way love. You persuaded him, you tried to persuade him to get married to you, but he refused. He was not interested in you at all. He said, no, I don't have that inclination towards you. Then, in order to see to it that you get a wonderful, handsome groom, you and your parents have tried this method and you have filed a false case alleging offense under section 376. Look at these three different types of stand that an advocate has taken. Can we take like this? It is not advisable. We are not supposed to take this. In fact, one sessions judge, one Mr. Rahman, has written a wonderful article in which he refers to all these things. It's a beautiful article that he has written. We say another case that's where we say keep track of what you are asking. That's where be on track is one of the disciplines that we have to calculate if you want to be an expert cross-examiner. Next, another case history, an offense under section 489A, not 498A. 498A, all of us know. 489A, the counterfeit notes. The situation was slightly different. PW1 is a sub-inspector who conducted the raid and seized the counterfeit notes. Cross-examination. The advocate is telling like this. These are all hypothetical cases, let us think for a while, because I'm not here to, condemn my own brothers or tell something. If I told you fairly where I had gone wrong, it's a learning process. Sometimes I go wrong, sometimes you go wrong. We learn from each other's mistakes, that's all. There is nothing wrong in discussing this because we are in a learning process. This is one case where the cross-examination goes like this. I suggest you that you never arrested the accused nor seized the notes, and the accused was never available at the place. This is what is given to the investigation officer, sub-inspector. He says, no, I deny. Another session. You secured these counterfeit notes from somebody else You allowed him to escape, but you fostered a false case against this accused who is innocent. Inspector says, I deny. Okay. After 2 months after this, the expert comes. Because in counterfeit cases, note cases, expert has to certify whether the notes are genuine or counterfeit notes. The expert comes. So the first question this gentleman puts, what did you do to testify that these notes are counterfeit notes? He said, I tested the thickness, I tested the silver line being there, the RBI guideline is there. So he will tell, he's an expert. So he will tell, he said all those things, he explained in detail what all he did. Now, this person has forgotten what he has cross-examined the sub-inspector on the first day, 2 months back. Now he is giving this suggestion to this expert. I put it to you that the notes were genuine, but you have given an incorrect report that they are forged, they are counterfeit notes. How do you appreciate this? There your case is that your client was not at all there and there was no arrest, raid, or he was not available. From somebody else, the notes were taken. Those were counterfeit notes taken from somebody else. The sub-inspector had allowed that person to escape, but fostered this case against this person. That is your case there on that day. But with another witness, your case is different. This cannot. That's where we say stand on the track, be on the track. When you're that, I really sometimes it's very important to note that this piecemeal cross-examination is condemned by Supreme Court. Supreme Court has said you should never do piecemeal cross-examination. And in addition to that, I always suggest that one who has cross-examined one witness, if the same lawyer cross-examines another witness, it will be wonderful. If some other lawyer steps in, it will be really difficult. Or you should have all the material. Of course, in some cases where I did not have much knowledge about this fingerprint technology and all in those days, after some lawyers, I had availed the services of some lawyers who were experts in that field to cross-examine. With regard to experts, you can do that, but not in all cases. But as far as cross-examining an expert is concerned, do not enter into their area of expertise at all, because however you try, we may have working knowledge or the domain knowledge, to some extent working knowledge, but we will not have expertise and experience that that particular has got in that field. So you must be very careful in noting down what you should ask and what you should not ask. This is the second case. Now you see, I will take you through some other interesting case. It's a case where how far we can take risk is one element. There was a dispute between sister and brother with regard to property. Civil dispute between brother and sister with regard to property. Sister was a widow. Brother wanted to have all the property, but somehow sister, when she demanded partition, brother was very angry. The sister's daughter was stabbed. Attempt to murder was the case. Now, who is the complainant? Mother is the complainant. This is the scenario. Cross-examination goes like this. Mr. Rajshekhar is your brother? Yes. There are civil disputes? Yes. Where did this incident happen? It happened when the sister and her daughter had come to revenue court, where there was a case, revenue case against this Rajshekhar brother with regard to entries in the revenue documents, Pahani, etc. So the sister and her daughter, both of you had come to revenue court? Yes. Say how yes is dichotomous answers are being, dichotomous questions are being put, and how yes or no answers are being taken here. You and your daughter went to the revenue court. Yes. There was a dispute between you and your brother. Yes. You both entered the revenue court. Yes. DC was there. Yes. The case was called. Yes. Your brother was not there. Yes. You both signed in the order sheet. Yes. Your brother did not come. He did not answer, he was not present. Yes. The court gave adjournment. Yes. You came outside. Yes. Then what happened? My brother came and stabbed my daughters. My brother came all of a sudden from outside when we were moving out, and he tried to stab me. My daughter came to protect me, and the knife he stabbed my daughter. This is what she said. The cross examination is like this about this aspect. What did you do immediately? I shouted. What did you shout? This is a bipolar question. She could have given her own answer. She could have said, look, my brother has hit my daughter or stabbed my daughter. But she said, someone has stabbed my daughter. Someone has stabbed my. This, he need not have asked. He has taken a risk. But the lawyer was so sure. Very brilliant lawyer. He asked this question. Then this lady said, I said someone has stabbed because my brother had put monkey cap. Look at this. Monkey cap, you know, the monkey cap, you cover everything till see who has stabbed my daughter at that point of time. So I said, someone has hit, someone has. IO comes. What are the material objects seized? The knife that is used for stabbing, the blood-stained clothes of the daughter. That's all. You did not seize anything? No. You did not seize any cloth of the accused? No. That's all. No cross-examination, Your Honor. See here. What was material here? Even the monkey cap should have been there, isn't it? The monkey cap was missing. She said, someone has stabbed my daughter. So these are the elements because of which the matter ended in acquittal. This is how a brilliant cross-examination goes. You should see the whole picture and you should navigate in such a way. You should know when to stop, where to stop, what to ask, what risk you can take, what risk you should not take. This is another case. Let us go to another case. It's a matrimonial case. Wife has filed a petition for divorce and husband has filed a petition for restitution. Husband is very much interested in reunion. However, we tried, it couldn't. My junior colleague, who is a wonderful cross-examiner, our case was that the wife was taken the best care. Still, for her own reasons, she came to India with her child and she has taken a call not to go back with the husband. This is our case. Several photographs were shown where husband, wife, and the child were there together in different places. All the photos, there are about 300 to 400. Each of the photographs were shown. Look at this, look at this. You are here. No, it is not me. This is you. No, it is not me. In all the 300 photos, she says, it is not me, it is not me, it is not me. Okay. What do you do? Just, so after 10 or 15 photos, all the 300 photos were handed over to her. She said, in none of these photos I am there. Okay, fine. This boy, just my junior colleague, he cross-examines on different aspects. And then he says, you have filed a petition for divorce. Do you think you can live independently without a husband? Yes. Okay, you are very bold. Yes, I am very bold. You have traveled worldwide? Yes. You might have seen several countries? Yes. More than 10, 15? Yes. You have seen Las Vegas? Yes. You have seen Belmont? Yes. You have seen Paris? Yes. When did you go to Paris? About 5 years back or 6 years back, or when? About 4 years back. Okay. All these different places, everything after marriage. And some places suddenly you will ask, this place, with whom did you go? I, my husband and child. Here, I went with my mother-in-law. Here, I went with my mother-in-law, father-in-law and sister-in-law. Look at this. This is how you collect. What answer you cannot directly get, leave it at that. You cannot be, look, this photo is yours only. I suggest that this is your photo only. Look at this photo. Nothing. He took it in a different manner, because now that with digital photographs, you know, you will get the time, year, everything on the photos. So I went to Paris 5 years back, means there will be year also mentioned there, 2015, 4/5/2015. So that you can request the court to consider that. This is how your cross-examination should go, is another thing. Now you see, when we look at all these things, another aspect that comes to my mind is the one case where this rating scale questions, I told you how to make use of this rating scale question, and how to take, into consideration the topography of the place where the incident has happened, alleged to have happened or happened, whatever it is. I suggest those who are doing cross-examination in criminal cases, visit the spot or get a video of the spot and then see everything meticulously and then proceed with the cross-examination. There was a case where the uncle had hit his brother's son with a huge iron pipe in the field, and immediately that person, that young boy, fell down in a pool of blood, and he was taken to hospital. This is the offense, attempt to murder once again. The question here is, who are the eyewitnesses? There were 2 eyewitnesses. So the question is put, the cross-examination goes like this. Where is your land? Next to this victim's land. How big is your land? About 5 acres. Okay. Victim's land, 5 acres. Where were you standing? I was standing. Where is your house? My house is in the beginning of my land. That means at one edge. Where was he, the victim, at the time of incident? He was in front of his house. Where is the house? Is it immediately next to your land or at the farther end? It is at the farther end. So how big is victim's land? It is about 8 acres. For 5 acres plus 8 acres is 13 acres. So where are you standing? You are standing in front of your house in the beginning. So at the beginning of first acre you are standing, and where the incident has happened? At the end of 13th acre. Okay, that's also okay. What is the crop that was grown there? Jowar. It was fully grown? Yes. Why you people did not cut? In our village, we all cut collectively. So kata was not done. We were waiting for 2 or 3 days to go. Then we decided to cut it. That's why. So what is, is there a borderline between your land and his land? No, there is only a brick line. Cross-examination stopped. No further questions. Summation he did not go. But the lawyer argued at the time of arguments that, look, from the starting point of 13 acres, what he could have seen with the jowar crop growing so high, when something had happened at some other place at a distance of 13 feet. This is how the inference is requested to be drawn by the court, with the frame in which the fact is requested to be seen. Now, in this case also, there was one more aspect. The victim had gone there by JCB. So the complainant was the father of the victim. In complainant's cross-examination, the lawyer asked, okay, what happened? The JCB driver informed me. JCB driver informed me that uncle had hit, your brother has hit your son, so please come. And I am taking him to hospital. Okay. The JCB driver was not made a witness. This aspect was taken into consideration and confronted to the IO when he was summoned as a witness there, prosecution witness. This is one aspect. Second aspect is to the complainant itself. Lawyer asks very intelligent question. He asks, okay, the JCB driver informed you. Then what did you do? I went to hospital. I see to it that my son gets all treatment. Then somebody suggested you should not be waiting. You should immediately go and lodge a complaint. So I went. When the first incident happened, on 1st of May, the incident has happened. So you went and immediately around 11 o'clock, you went and gave the complaint. No, I went there till 2:30. I waited there. 2:30 only the respective inspector came. Then he took everything. I came there afterwards. I came from there afterwards. Okay, fine. You see the FIR, there is an explanation. In the complaint, there is an explanation that the complaint was lodged 4 days after the incident. And there is a reason for delay also, that because he threatened to kill me also, I did not lodge the complaint immediately. But look at what this person has said. I lodged the complaint on the first day itself. But here he is giving an the document shows, when you are asking the foot question, the document says that he has given the complaint 4 days after the incident. These are the leverages that were taken by the advocate for the accused in order to see to it that the accused is acquitted. These are some aspects that you need to consider. Another case that I would like to share with you is a case where a will was executed by a doctor in favor of his former wife. That means divorced wife. He had divorced his wife, and he had married another lady. Somewhere a guilt factor was working within him. So he executed a will in favor of his former wife. There was a big fight. The will was in his handwriting. The handwriting of doctor. Doctor himself had written the will, and there were 2 witnesses. Okay. The lawyer puts the question very intelligently. Nothing, because the signature, everything is, sorry, the will, because it was in the handwriting of the doctor itself, that was something very crucial. Okay, this will, who has written all these things? Doctor. Okay. You are witness. Okay. What's your name? So and so. It is written in capital letters. Yes, my name is written in capital letters. Another witness, Shri so and so. Foot questions, all foot questions. Document is being shown at every juncture. Yes, his name is Chamrao. It is written here. Which is your signature? It is my signature. What is your? What is this? This is signature of that another witness, Chamrao. Okay. What is this? This is Dr. Satnarayan Rao. Who has written this? Dr. Satnarayan Rao himself has written in capital letters. Yes. Now he could have stopped there, but lawyer took a brave step and he said, there is no signature here. Look at this document. You are giving the document. Reflective question. You are asking him, please listen to me. You look at this document, and looking into the information that I have provided you, you answer the question. Dr. Satnarayan Rao is written in capital, but he has not put his signature. Yes. No cross-examination, further cross-examination. The will was disbelieved by the court because the court said the person had written the will, but he had virtually written the will. He had withheld signing the document. Maybe something was going on in his mind, because there is one decision. You have to sit in the armchair of the person who is going to bequeath and then see what would have gone in his mind to see whether the will is genuine or not. To remove the clouding circumstance, that's where your knowledge of law also comes into subject matter of preparation. You should know all the leading citations where a will is believed or where a will is disbelieved. So this clouding circumstance was enough for the court to disbelieve the will. This is how the entire, the process of cross-examination goes. So all said and done, I say that ultimately you should be thorough with the legal provisions. Order 18 you should be very well aware of. Section 137 you should be very well aware of. 280 you should be very well aware of. You should know leading decisions on the point. You should know the recent development in the field of, appreciating the expert's evidence, how far the court is going to believe the expert's evidence. All these aspects you need to know. And if you do not have the expertise in a given field, it is better you assist another advocate who has got better expertise and get the cross-examination done through him. I think there is about 15 minutes left. I request all of you to consider if you have any questions that you would like to ask or any discussion that you would like to go ahead, so that we will not go beyond schedule. I will always try to limit myself within the time that is given to.
Thank you, ma'am. Thank you. Now it's time for asking questions. Those who want to ask questions, please raise your hand so that I can unmute them. Please.
Madam, please give an example for accelerating questioning. Accelerating.
Escalating technique.
Yes, technique. One example. Please give an example.
Example. Yes, I'll tell you. See here, you don't go straight to the question that you are asking, but you start with something and you go there. I told you that example where my junior conducted a cross-examination.
Yes.
He did not say that you and your husband were enjoying well, you went to different countries, you enjoyed your life, married life so well, nothing. But he started from somewhere, went step by step, step by step. You don't go to fourth gear all of a sudden, isn't it?